morning, everyone. It's my great pleasure to welcome here today Professor Marc Steinberg, Radford Chair Professor at the Southern Methodist University, Tubman School of Law, for today 20th AIIFL Distinguished Lecture in Financial Law. This milestone lecture continues a tradition that AIIFL has cultivated for over 2 decades, and we could not have a better speaker to mark this occasion. Professor Steinberg is a relationship with AIIFL is not a recent one. It dates back to our institute's very establishment in 1999, when he joined our academic board and has remained a key advisor, collaborator, and a friend to the Institute ever since. For those who may not know Professor Steinberg's remarkable credential, I will just briefly mention few elements, I will say few numbers to start. He's probably the most, undoubtedly, the most prolific author in securities law scholarship in the United States and surely globally, with over 50 books and more than 150 law review articles published. He serves as editor-in-chief for the International Lawyer and the Securities Regulation Law Journal, two of the most respected journals that we have in the field globally. And his career includes service as an enforcement attorney at the US Security Exchange Commission, working directly with the General Counsel, but he also has been retained as an expert witness in some of the most significant cases in corporate law matters in our recent history. I want to name them, but we know. More recently, Professor Steinberg's latest book, published with Oxford University Press in June 2025, and titled Corporate Director and Officer Liability, Discretionaries, Not Fiduciary, has been awarded several prizes. He has been the winner of the Best Business Book of 2025 in the United States. And it has received extraordinary prizes from judges, scholars, and policymakers alike, precisely because it advances a bold idea that we will learn more about today. But the idea, just to say a few words, is that challenges what are the deeply ingrained principle that has been persisted over century and characterizing the liability of corporate directors as within the scheme of fiduciary duties. And then his thesis, without anticipating much, is that this is essentially a fiction, because the lenient liability and the fact that actually accountability is effectively placed depending on circumstances and type of individual will actually lead to consider fiduciaries this type of relationship as a misnomer with potential detrimental consequences. Instead, he proposed something different, the term discretionaries, as we will learn further. So without any further delay, please help me to welcome Professor Steinberg, and Marc, the floor is yours.
Thank you. Thank you for having me at this preeminent law school. Professor Castellano, I'm very appreciative. I'd like to say hello to Professor Arner, previous director of the Institute, who I'm proud to say is my former research assistant at SMU. Professor Arner and I have known each other for more than 25 years, clearly, I think more like 30 years, and congratulations on your distinguished career, as well as Professor Castellano, congratulations on your distinguished career. It's always an honor for me to be here. This is a great, great university, and Hong Kong, of course, is one of the most beautiful cities in the world. As Professor Castellano pointed out, I'm editor-in-chief of 2 journals. The first is the International Lawyer. This is an American Bar Association publication. It is received throughout the world. It's peer-reviewed. perhaps the most widely circulated international law journal in the world. The other is the Securities Regulation Law Journal, which also has a number of global scholars who write for this. This is a Thomson Reuters publication. I might add, for those of you who are PhD students, both of these sources are available for you to submit articles. For example, I see here that one of the articles in this journal is written by a PhD student at the Chinese University of Hong Kong and was accepted for publication. This is the book that I wrote, Corporate Directorate Officer Liability. I guess I won't pass that around, but if you'd like to look at it afterwards, of course, please do. And if you'd like to look at the journals, please do as well. And for those of you who are thinking about getting a second Masters of Law program at SMU, where I'm from, we have a very extensive international master's program. And in fact, we have the Solomon Scholarships, where every year we give 5 students from China a full scholarship. And not only a tuition scholarship, but also a stipend that they can live off of. And we have the very best Chinese students in China coming from their premier law schools. And we really haven't had, I don't think, any students from HKU lately, and it would be wonderful, of course, to have them. Well, wonderful. Thank you. So this book, how did it arise from this book? Well, I've been teaching this subject for longer than many of you have been alive. I was thinking that I began teaching this course in 1982. And the problem today is, if I say that I began teaching in 1982 and I was 12 years old when I began teaching this course, it would still put me in my mid-50s. That's kind of I wouldn't say quite depressing, but let's say sobering thought. So I've taught this subject for years, and of course I've seen the law change. We're talking about 4 decades. That's a good amount of time. When I began teaching, directors and officers were subject to some meaningful duties. As times have changed, the law has become more and more relaxed. And what's interesting is that as the law became more relaxed, and in the United States, when we had financial fallouts or financial fraud, such as the Enron debacle, what we had was Congress, the U.S. Congress stepping in and federalizing corporate governance. In the United States, company law is a matter of state law, generally speaking. And the law that applies is the law of the state of incorporation. For publicly held companies, the premier state is Delaware. So that Delaware company law is the major source which one would look at to look at U.S. company law. What has happened recently is that other states have decided to compete with Delaware far more vigorously than before. And the reason is to a large degree revenue. These companies incorporating in respective states such as Delaware or Nevada or Texas, these states receive what are called franchise fees, and they can be quite substantial with respect to the amount of money that a state can bring in. More recently, Texas, which of course is the fastest growing state in the U.S. as far as population and economic growth. I believe 4 of the 10 largest cities in the United States are in Texas, certainly among the top 15. I'm speaking of Austin, San Antonio, Dallas, and Houston. So it's a very big area. So for example, those of you who are thinking about getting the Master's of Law, yes, Columbia, NYU, Harvard, Yale, Stanford, University of California, those are all wonderful schools. What SMU offers in Dallas is perhaps the fastest growing economic center in the United States, where there's a lot of opportunity for global lawyering. Also at SMU, I might add that I'm the director of what we have is the corporate externship program. In the fall semester, we send roughly 120 students into corporations based in Dallas and virtually throughout the U.S. to serve as student externs. These students spend about 12 hours a week working with the company. They have a very meaningful experience, and this program includes many of our international Masters of Law students. To get back to the subject from what I'm here, so as the years go by, what I noticed was that the law was getting more and more lax with respect to the duties of corporate directors and officers. And I like to go for walks. When I go for walks, I think it's good for my health, breathe the fresh air, and also I have time to think. A lot of times if I'm working or I'm watching television or driving in a car, I really don't have time to think. And sometimes when I walk, just random thoughts come to my mind. So I'm taking a walk one day, and this happened with my book, Rethinking Securities Law, which was published 2021 by Oxford University Press, and the Federalization of Corporate Governance that is also published in Oxford in 2018. All these ideas came to my mind as I was just taking a walk in my neighborhood. And I said to myself, these people, directors and officers, are still being called fiduciaries. And this is a misnomer. This is a fantasy. And no one has really written about this. Sure, people have written about the lessening, the decreasing of fiduciary duties, but no one has really said, are you kidding me? These people are not fiduciaries. We are calling them by the wrong name. So I said, well, I've got to come up with something here. And then good morning, welcome. Certainly. So I go home, I get out a subject matter index very quickly, topical index. Of course, I work on it and I send it off to the publisher. I really like Oxford University Press. They've treated me very well. And I'm sorry, Doug, I just don't like the book covers for Cambridge. They put on these funky book covers, and I don't care for that so much. Also, a nice thing about Oxford is that they have a book jacket. And of course, Cambridge does not. And it's fun to have a book jacket with the quotes in the back. Thank you. And then, thank you very much. And then, of course, even my photograph. I can pretend that I'm a best-selling novelist, as I get my royalty check for $800 US. So I'm thinking, okay, if they're not fiduciaries, then what are they? I've got to come up with a term, right? I've got to call them something. They're not fiduciaries, okay? So what are they? And I said to myself, I've got to come up with a neutral term. If I come up with a term that's critical, then the book is likely going to lose its legitimacy. The response is that even though I have very good practical experience for a professor, the response is that, oh, this is written by a law professor, and he or she really doesn't understand what goes on in real life. For those of us who are professors, we've heard that from practitioners before. Of course, we disagree with that statement. And then all of a sudden, for whatever reason, the term discretionaries came to my mind. And I said, I don't know if you like the term, but I said, I really like this term because it's a neutral term. And what it means is, in this context, is that directors and officers have a specified amount of discretion, and it changes upon the facts and circumstances. At times, relatively rarely, their discretion is relatively narrow. Other times, their discretion is nearly boundless. The only small problem is that the word is not in the English dictionary at this time for this purpose. It generally means, buying commodities that are discretionaries. You don't have to have them, but I like to have them. They're discretionaries, looking it up in the English dictionary. So I've used the term in a new way, and we'll see if it finds its way in the English dictionary this way. And what I did when the book was published is that I sent the book to all the Delaware judges, and Texas is a business court, and I made sure that those judges had the book. And fortunately, a current Delaware judge, as well as two former Delaware Chief Justices of the Delaware Supreme Court, gave very nice statements on the back of the book. So I'm hoping that the term discretionaries will find its way into a judicial decision, and then hopefully we'll get rolling. I may be fantasizing about this, wishful thinking. We'll see. I can only basically do so much, right? I really cannot write the opinions. I'm not a judge, so I've done what I can. So the next question is, why are they? Why is this a misnomer? Why is it an improper term? Well, think of the term fiduciary. Generally, what does it mean? And is Black's Law Dictionary looked as an authoritative source here? Yes. Okay, great. So Black's Law Dictionary basically says that a fiduciary is one who acts with reasonable care, in good faith, and with loyalty to the persons to whom that duty is owed. And then at the end of that definition, it has a slash and says, corporate officer is a fiduciary, as an example. So that's basically the term: reasonable care, good faith, duty of loyalty. So let's see how this plays out. For example, let's look at the duty of care. And before I get there, there is a broad difference between what are called standards of conduct and standards of liability. Standards of liability are also called standards of review. When you look at many of the U.S. court decisions, what you'll see is very strong language of what directors and officers ought to do. And these are called standards of conduct. But really, these are best practices. They're exhortations. The failure for a director or officer to comply with these standards of conduct, they have no bearing on the question of liability. Standards of liability, on the other hand, are extremely lax. So that there therefore has to be distinction between standards of conduct and standards of review, and at times the courts conflate or confuse these two principles. So let me provide an example with the duty of care. The standards of conduct is that a duty, and you'll see this in the Model Business Corporation Act under U.S. law. And of course, my analysis goes here principally to U.S. law, needless to say. This is not a global interpretation. This is an interpretation of what is happening in the United States. But generally, if you look at the Model Business Corporation Act adopted by the American Bar Association, court decisions, when you look at the standards of conduct, it generally is a fiduciary standard that a director is to act with reasonable care in light of the circumstances, in light of his or her expertise, background, experience, and so on. So it's both an objective and a subjective standard. The standard that I understand that applies here in Hong Kong. But when you look to standards of liability, what is the standard that would apply with respect to subjecting a director to liability? It's that of gross negligence. So that under the duty of care for liability purposes, a director would only be monetarily liable if he or she acted with gross negligence, defined by the Delaware courts as a wanton disregard or reckless indifference. Wanton disregard or reckless indifference. In the United States, that type of conduct in many situations would subject a defendant in a civil case to what are called punitive damages. In other words, excessive damages beyond compensatory damages. But yet that's the standard that must be shown in the United States for a director or officer to be held liable for the breach of the duty of care, at least in Delaware and many other states. Now, when I said that the courts sometimes conflate the standards of conduct versus the standards of review, I have this great quote. I didn't say the quote, but the quote is in a Delaware Supreme Court decision in a case dealing with Facebook and Mr. Zuckerberg. And this is what the court says. And you read this and you say, really? how did this ever make its way in a published form? And I quote, predicated upon concepts of gross negligence, the duty of care requires that corporate fiduciaries inform themselves of material information before making a business decision and act prudently in carrying out their duties. I'll just repeat that. The court says that it's predicated upon concepts of gross negligence and that therefore directors are to act prudently. Clearly, prudence and gross negligence are two very different things. So there you have an example, Professor Arter, of the Delaware Supreme Court, really the best Supreme Court state and company law matter, making a huge mistake here. They're saying the duty of care is premised upon gross negligence, and that means that directors act prudently. Well, that's not gross negligence. Gross negligence is wanton disregard. So what we have here is simply a mistaken statement by the Delaware Supreme Court that somehow made its way, and this decision is only 4 years old, made its way to publication. So that's one example. Let me turn to the business judgment rule. The business judgment rule, many countries don't have a formal business judgment rule. My understanding is that Hong Kong does not. And of course, Professor Castellano, please correct me if I'm mistaken at any point here, because you know Hong Kong company law far better than I do. But in the United States, the business judgment rule is the foundational rule for board of director conduct. And what are the elements of the rule? They are that there's a deliberative decision that is made. That means a decision to act or to abstain from acting. Secondly, that the board is adequately informed. The third is that there is not a disabling conflict of interest, such as a duty of loyalty issue. And the fourth is that the decision is made with a rational basis. So to review that, a deliberative decision, adequately informed, made without a disabling conflict of interest, and having a rational basis. The standard for rebutting the business judgment rule that a plaintiff must show is, again, gross negligence, that the directors acted with wanton disregard, reckless misconduct, and so on. And what is the policy behind the business judgment rule in the United States? And that is, and this goes back over 100 years to a case called Ford versus Dodge, Ford Motor versus Dodge, is that judges are not business experts. That to have directors, board of directors decisions second guessed with the benefit of hindsight is unacceptable. That business is a risk-taking venture, many decisions fail, and that to impose liability based upon ordinary negligence would be too severe a standard, and applying this to modern times, it would also deter independent directors from serving on corporate boards. And of course, deter risk-taking that sometimes is essential for corporate growth. But what's a statement I really like? And that is a statement made by Vice Chancellor Laster of the Delaware Court of Chancery. The Delaware Court of Chancery is the trial court in Delaware. The case is tried by the chancellor, him or herself, and not by a jury. But basically what Vice Chancellor Laster said in a decision about 3 years ago, it is that it is harder for a plaintiff to rebut the business judgment rule than it is for a prosecutor to be able to successfully prosecute someone for criminal negligence. So in other words, it's harder for a plaintiff in a civil case to rebut the presumption of the business judgment rule by showing gross negligence than it is for a prosecutor in a criminal case to be able to obtain a conviction for criminal negligence. So that therefore, it is easier to send someone to prison for criminal negligence than it is for a plaintiff in a civil case to rebut the presumption of the business judgment rule. And these people are called fiduciaries? Are you kidding me? Okay, so I'm just getting going here. So what the book does is it covers these issues in a very seriatim way. It goes example by example by example by example. In other words, my point here is to be able to basically present an irrefutable case. I'm, for example, the prosecutor, and I really want to lay this on so that the response is, oh, he gave 3 or 4 examples, and there are only 3 or 4 examples. What I tried to do here was cover duty of care, duty of loyalty, derivative litigation, mergers and acquisitions, closely held corporations, and just show by example that fiduciary standards, for the most part, do not apply. At times they do, as I'll discuss in a few minutes, but for the most part, they do not. Now, also in the United States, there's something called exculpation statutes. And what happened was that in 1985, the Delaware Supreme Court handed down a decision in an M&A context holding the directors of an acquired company personally liable for breach of the duty of care. The court held that the directors acted with gross negligence in approving a transaction without being adequately informed. The case eventually settled for $21 million US. And directors were very, very upset about this. There were rumors that the availability of insurance may become problematic, and that other states started stepping forward and adopting exculpation statutes. And Delaware knew it had to respond, and it adopted its own exculpation statute, which is the majority rule today. Now, whether it remains the majority rule, we'll see, as I'll talk about I'll talk about the Texas and Nevada statutes in a moment. But under the Delaware statute, if a corporation includes a provision in its articles of incorporation, a director and an officer, and for officers only in direct actions, not derivative actions, can only be held liable monetarily if they engage in a loyalty breach or they act with intentional misconduct. So that in Delaware and the majority of states, if a director does not act in breach of his or her duty of loyalty and acts with reckless misconduct, that is not sufficient to impose monetary liability. The misconduct must be intentional. Again, another example that these people are not fiduciaries. What has happened is in Texas and Nevada, these states are trying to induce corporations to incorporate. So the legislatures passed even more permissive statutes. And the Texas statute was just passed last summer. Let me go over the Texas statute, which is, to me, unbelievable. I did talk to 3 state legislators about this statute. I explained to them why this statute made very poor policy, and I had absolutely no impact. But I tried. So they listened to me courteously and then went ahead and voted for this statute. So what this statute says is and there's no requirement for a publicly held corporation here to put this in its articles. In other words, it automatically applies to companies that are publicly traded. A company could put in its articles that it could opt out of the statute, but there is no requirement that the company have to have an amendment in its articles that the statute applies. What this statute says is that for a plaintiff to recover monetary damages, the plaintiff must prove first a breach of fiduciary duty. So fiduciary duties in the US encompass both the duty of care and the duty of loyalty. The duty of good faith is encompassed within the duty of loyalty in the US. So once that's shown, that's the first step, first part of the case. And then here's the second part. In addition to showing a breach of fiduciary duty, a plaintiff must show that that breach was committed with intentional misconduct, with fraud, or a knowing violation of the law. In other words, breach of the duty of loyalty, Director is only liable for misappropriating funds from the corporation, for example, or taking a corporate opportunity, or engaging in a self-dealing transaction for his or her financial benefit. First, if a court finds that that is in breach of the duty of loyalty, but is only held liable if, number two, the director committed that breach with intentional misconduct, acted fraudulently, or in knowing violation of the law. Wow. Fiduciaries? I don't think so. And Texas has not stopped there. Texas wants to outdo Delaware now to induce companies to come to Texas. Practically all these suits are derivative suits, which surely means that these suits are brought by a shareholder who is an eligible shareholder on behalf of the corporation. Any recovery, of course, after attorney's fees are paid and expenses, goes to the corporation. And my students sometimes ask me, how do you differentiate an individual action from a derivative action? And I think the easy response is, and there are exceptions, of course, but the general response is to look at the alleged misconduct and say, who is the party most directly harmed? Is it the corporation or is the individual shareholders? So when we're looking at these generally duty of care and duty of loyalty situations outside of the M&A context, we're generally talking about derivative actions. Let me give a few examples. That the company approves an excessive executive compensation package for its chief executive officer. The corporation, of course, is the party most directly harmed. The CEO sells her vacation property to the corporation at an excessive price. Clearly a derivative action. A corporate director or officer usurps a corporate opportunity. Again, a derivative action. The board acts in breach of the duty of care in undertaking a corporate transaction, or in failing to close a plant that was having a negative impact upon the corporation's earnings. Again, a derivative action. Well, what Texas has done now is that publicly held corporations, by a board of director bylaw, so this is without a shareholder vote, can have a provision requiring that in order to bring a derivative action, a shareholder must own at least 3% of the company's stock. Now, shareholders can join together to get to this 3%. But for example, Tesla reincorporated in Texas. Mr. Musk likes Texas. How many shareholders in Tesla, other than Mr. Musk, own 3% of Tesla stock? My guess is 0. I don't know that for sure. But even if you go away from Tesla, there are very few shareholders. Perhaps an institutional shareholder, a insurance company, perhaps a company like Vanguard or Transamerica. Perhaps they may own 3%, but it's rare. Certainly not. And of course, some active shareholders may own 3% if they're going to mount a proxy fight. So of course, it does occur. But my point here is the number of 3% shareholders in a publicly held company are sparse. So that means that Mr. Musk can arrange these arrangements. I'm not saying that he's not acting in what he perceives as the company's best interest. So I'm not saying that. But if it is alleged that the board is acting improperly, and there is an alleged breach of the duty of loyalty, in Texas, there's not going to be even an opportunity for a suit to come forward. So this is rather amazing in my view. Now, I've been asked, and of course, it's not like I look through my crystal ball. I mean, I can look through my crystal ball and come up with wrong answers quite frequently. And one of the amusing things I find, I don't know if you find this at all, Professor Castellano, is that because I know securities law, people think I know how to invest in the securities markets. And at least, I've done okay, but I wouldn't consider myself a maven, but they think I also know how to invest in the securities markets. and here I am. So, but regardless, even if I did, I would still consider it an honor, as I do right now, being at this preeminent university. So that therefore, in Texas, these suits can't even be brought. And I've been asked, well, what do you think? Do you think companies are going to go to Texas? And my reaction is companies with controllers, yes. I mean, this is a perfect haven for a controlling shareholder to incorporate, because basically you can do what you want. It's almost like it's your privately held company, and although you have to be concerned with perhaps state action once in a while, for the most part, you can do what you want if you're the controlling shareholder. And that is what has happened in Texas, that these controllers who have these companies that are incorporating in Texas, and also your smaller publicly held companies, less regulation in Texas, favorable corporation law. These companies don't have large institutional shareholders generally. They're incorporating in Texas some. But my personal opinion is when you look at the New York Stock Exchange companies, your large NASDAQ companies that have a fluid investor base where there's significant institutional investor participation, they're not going to go to Nevada or Texas because it's shareholders that have a meaningful say will say no. Will say no, and it will have a detrimental impact on corporate governance for that company. We'll see if I'm right or wrong. What about the duty of good faith? The duty of good faith is part of the duty of loyalty. And this aspect in Delaware law has really emerged with respect to law compliance and risk management. And the standards of conduct in Delaware is that the board needs to be proactive, to have law compliance procedures, to have risk management. So what's a case that we all know is the Boeing situation. Boeing involved a situation of law compliance, risk management, in which the board did not conduct adequate oversight. The question is, what is the standard of liability for failure to exercise good faith under Delaware law? And I quote here, this is from a Delaware Supreme Court decision, which is good law in Delaware, and that is the plaintiff must prove that the defendant directors, quote, utterly failed to implement any reporting or information system or controls, or having implemented such a system or controls, consciously failed to oversee its operations. So note here, again, the divergence between standards of conduct and standards of liability. Standards of conduct is what's good practice, of course, and what is normally done because, corporations, of course, are concerned about shareholder lawsuits, but they're also concerned, of course, with government oversight, government enforcement actions, the impact upon public relations, such as what Boeing has suffered, a decrease in the market price, congressional hearings, and so on. So yes, this is important, these standards, but they're not exclusive as far as inducing corporate boards to adhere to standards of conduct. Because if they don't adhere to standards of conduct, there may be other collateral consequences other than liability under state company law. So here we have a situation where the standards of conduct is the board needs to focus on this issue. The board needs to continuously monitor this situation, especially if, of course, this function is a core function of the company. Building aircrafts is a core function of Boeing and airline safety. But for liability purposes, the standard is conscious failure. In other words, deliberate misconduct. And by the way, in the Boeing case, the Delaware Supreme Court did allow the case to go forward. I believe it was the Delaware Court of Chancery actually let the case go forward, and it eventually settled for several $1 million. And of course, this is how the plaintiff's lawyers get rich get rich in the United States. If you're a corporate partner in the United States from a large firm, from a corporate firm like Sullivan and Cromwell, Cravath, yes, corporate partners make a very nice living, perhaps maybe $5 million a year. But again, in New York, they have to pay state income tax, and of course, they get taxed in a very high level in New York City tax. But if a person is a plaintiff's lawyer and lands one of these big cases, then of course they can make a fortune. An example that strikes me is that I was an expert witness in the Enron case. I was retained on behalf of the University of California, that was the lead plaintiff in that litigation. The plaintiff's lawyers did a tremendously impressive engagement representation. They recovered around $8 billion on behalf of investors. What were the attorney's fees? As I recall, they were somewhere around $750 million. So imagine these law firms and lead counsel splitting up $750 million. So this is how attorneys can buy, plaintiffs' attorneys can buy football teams. Partners at Cravath, they're not buying football teams. They're living in a nice house and so on, living a very nice lifestyle, but they are not buying football teams. Now, let me talk about related party transactions as an example where fiduciary standards sometimes apply. If there is a self-dealing transaction or a related party transaction, and if that is not approved by disinterested directors or by disinterested sharers, then the entire fairness test applies, which is a fiduciary standard. And that would require the director who benefits from the transaction to show that the transaction is entirely fair, meaning entirely fair as to procedure, including disclosure of all material facts, and substance, going to the corporation's need for the property or the transaction, for example. The price that was paid, is it a fair price? And a court scrutinizes that with the burden of proof being upon the director or officer who benefited from the transaction. That's a fiduciary standard. However, in publicly held corporations, that is for the most part unlikely to happen today very often. And why is that? Because as a condition of listing, a NASDAQ or New York Stock Exchange company generally must have a majority of independent directors on its board, which means that only in closely held corporations are you generally going to have this situation where you don't have independent directors. So that this type of fiduciary standard generally would apply only if you had a majority of the board who financially benefited from the transaction, or a plaintiff can show control or domination. Now, what's interesting is the court's analysis with respect to director independence. The Delaware courts say, generally speaking, that a plaintiff shareholder must raise a reasonable doubt that a director is not independent in order to move forward with its case. Once it shows half of the board not being independent. Now, some states have universal demand on the board, where regardless whether all the directors are interested, demand must be made. In Delaware, there is demand futility if a plaintiff can show that at least half the board is not interested. So there's this is the Zuckerberg decision again. And I talked about this in the book. And reasonable doubt generally means in the US, and of course that's standard in criminal cases in the US, is that there is no more than a 5% chance of doubt. In other words, if there's greater than a 5% chance that that, for example, the defendant may not be guilty, I've got a 7% feeling that that the defendant is not guilty, judges say, and this finding was written by 2 U.S. judges, that's not enough. There's got to be at least a 95% certainty or more. So that's the standard that the Delaware Supreme Court adopted, that a plaintiff must raise a reasonable doubt that the plaintiff is not independent. This is from the Zuckerberg decision. The plaintiff alleged that this one director was a close friend and mentor of decades with Mr. Zuckerberg. In other words, the plaintiff alleged with particular facts that this one director was a close friend of Mr. Zuckerberg, and also dating back when Mr. Zuckerberg was a young man, was his mentor. And the Delaware Supreme Court said that's not good enough. It's like, again, are you kidding me? That there's not at least a 5% chance that this director would side with Mr. Zuckerberg in some way or form? But that's what the courts held. So I have a small section here, it's 2-3 pages, about the fallacy of the reasonable doubt standard. So again, it's not only the standards that apply that are lax, it's the way that they are interpreted and applied in practice, that laxity prevails there as well. Let me just end with corporate opportunity doctrine. Here's another example that the general principle is that corporate directors and officers are not to take opportunities that are within the business zone of business that the company engages in or has expressed an expectancy in benefiting from. That's generally the rule in the U.S. Of course, there are different states have fine-tuned that depending upon the situation. But today in 16 states, so roughly a third of the states, including Delaware, the board of directors can pass a bylaw that permits directors, officers, and others, including controlling shareholders, to take specified corporate opportunities without any shareholder voice on this matter, such as an amendment to the articles. This can be done by a bylaw amendment by the board itself. That the board can simply permit directors and officers to take corporate opportunities. And then what about securities law as another example here? Securities laws are based upon disclosure, and the response was, well, what it really doesn't have anything to do with fiduciary duty. In one hand, yes. On the other hand, no. Because on several occasions in securities law cases and outside of securities law cases, the U.S. Supreme Court has identified corporate directors and officers as fiduciaries. They have said that in numerous decisions, at least a dozen decisions, including with respect to the law of insider trading in the U.S. Well, what has happened in the securities law situation? Under the main remedial provision, Section 10B of the Securities Exchange Act of 1934, a defendant, including a director and officer, would only be liable if he or she acted with knowing misconduct. So again, at least recklessness. Furthermore, with respect to forward-looking statements, in other words, such as projections of future performance, intentional misconduct must be shown. And also under U.S. law, there's the puffery doctrine that has been implemented, and that is the generalized statements of corporate performance, such as our corporate culture is law compliant and poised to bring corporate profits to greater growth. That is deemed to be a soft, puffery statement that's not actionable. So the response here is, and I don't know how the car sales business is done here in Hong Kong, but in the U.S., directors and officers are treated like automobile car salespersons. In other words, this car is so good, you'll never need another car again. People will admire you as you drive down the streets of Hong Kong of having the most beautiful car in the city. that directors and officers are treated just like automobile salespersons, that a CEO can simply get up and say, our company is poised to earn record profits in the next quarter. And that is deemed as a matter of law, not actionable. Soft, puffing statements. Again, this is not a fiduciary standard. And then lastly, let me conclude with why does it matter? In other words, okay, you've shown that they're not fiduciaries, but so what? These individuals have been called fiduciaries for centuries, and everyone knows they're not really true fiduciaries, but really, where's the harm? And my response is threefold. One is the law should be truthful. That's a fundamental statement. And here we're calling these individuals fiduciaries, meaning that a fiduciary in other contexts acts with reasonable care and good faith, with a duty of loyalty owed to that person. And here, that's not the standard that's applied. So the law is in fact untruthful in this situation, and that's unacceptable in my view. Secondly, a principle should correspond to the characteristics for which it is identified. Again, this is similar to the point I just made, and that is the characteristics of fiduciary is that that person act with reasonable care and good faith and with loyalty, zealous loyalty as a prudent person to those to whom the fiduciary duty is owed. And that's simply not the case here. And the third is separate, and that is that uninitiated retail investors may be deceived by this. In other words, retail investors, if they're not attorneys and so on, which many retail investors are not, and they're not sophisticated market investors, they look at directors and officers, they see that they're termed fiduciaries, and they may believe that these people are actually acting for their best interest. And if these individuals don't act in their best interest, the corporation's best interest, there will be liability consequences. And in fact, as I think, I hope you agree, has been demonstrated, they are not fiduciaries. They're not held to a rigorous standard, and that therefore these uninitiated investors may believe that the law is unfair, it's detrimental to the rule of law, and is simply unacceptable. In other words, it can be viewed as simply a false portrayal, which again is, in my view, unacceptable to the integrity of the rule of law. So let me end with this, with simply a quote, if I may. Perhaps the book ends with this quote, but it's only a few lines. And I quote, legal terms and concepts have impact. They are relied upon for what they claim to represent. In the corporate setting, fiduciary status presents the image that directors and officers are to act with reasonable care, in good faith, and with loyalty. And the failure to so act will give rise to enforceable remedial measures. In actuality, this is not the situation. Rather than engage in fiction, the status of these individuals should be characterized in an accurate and neutral manner. This portrayal should define corporate directors and officers as discretionaries and thereby accurately reflect their status. Thank you very much. Again, Professor Castellano, I'm honored to be at this premier law school. I always enjoy coming to Hong Kong. Thank you.
Thank you very much. It was undoubtedly our pleasure, and thank you again. And well, we'll for sure hope to see you soon again.
I hope so.
So.